This is an urgent legal analysis. A critical threat is emerging, not through new legislation, but through the deliberate disregard of established constitutional principles by federal agencies. The sanctity of your Fourth Amendment rights is under direct assault. The Department of Justice and the FBI have, by their own admission, engaged in actions that should send a chilling warning throughout the entire nation, regardless of political affiliation. We are witnessing a dangerous erosion of foundational legal protections, specifically the Fourth Amendment, which safeguards every American from unreasonable searches and seizures. The implications are far-reaching, setting a perilous precedent that could impact every citizen. The core issue here is a legal trap. The FBI's admission, contained within documents provided to the Senate Judiciary Committee, that the raid on a former president's residence was not necessary and was not the least intrusive option available. This stands in stark contrast to the agency's subsequent public narrative. The FBI's own internal email chain, dated August 1, 2022, explicitly requested the former president's cooperation for a consensual search, stating it would provide a level of comfort that the FBI has retrieved all appropriate documents. This single admission is devastating. It dismantles any claim that the raid, which occurred a full year later, was the only viable course of action. Constitutional law, firmly established by the Supreme Court, dictates that when a less intrusive alternative exists, law enforcement is expected to utilize it. The FBI did not claim uncertainty regarding the document's whereabouts, nor did they suggest documents were hidden or being destroyed. In fact, they provided a detailed, prioritized list of target locations within the residence. They also coordinated with the United States Secret Service, the National Archives, and the former president's attorney. These actions demonstrate a controlled, deliberate, and cooperative environment, starkly indicating the absence of exigent circumstances. Exigent circumstances are a crucial exception to the Fourth Amendment's warrant requirement, invoked only in immediate emergencies, such as a risk to life, fire, or the imminent destruction of evidence. None of these conditions were present. The FBI explicitly stated they were seeking two categories of materials: classified or allegedly classified documents, and documents covered by the Presidential Records Act. However, the Presidential Records Act is a civil records management law, historically resolved through negotiation, not through armed raids on private residences. By deliberately blending a civil matter with criminal classification claims, the FBI escalated a non-criminal issue into a full-blown criminal spectacle. This is not merely unusual. It is a dangerous weaponization of legal processes, setting a precedent where civil disputes can be twisted into justifications for aggressive law enforcement tactics. The constitutional requirement of reasonableness for searches and seizures was clearly undermined. Reasonableness, as defined by the Supreme Court, is the standard, not convenience, not political expediency, and certainly not public messaging. The FBI's own documents confirm that cooperation was possible. Alternatives existed, locations were known, and legal counsel was engaged. There was no exigency. When law enforcement chooses force over cooperation without necessity, it is a flagrant violation of the Fourth Amendment. The implications of such actions extend directly to individual liability. Under Title 42, United States Code, Section 1983, any government official acting under color of law who violates constitutional rights can be sued personally. This liability extends beyond those who physically executed the search to include any agent, supervisor, or official who authorized the operation. It is a fundamental principle that law enforcement officers are bound by the Constitution. Orders that violate constitutional rights are not to be followed. It is critical to understand that violating the Fourth Amendment does not require physically kicking in a door. Merely authorizing or participating in an unreasonable search is sufficient. The FBI's own documents, demonstrating their knowledge of cooperative alternatives, constitute precisely the kind of evidence used to defeat qualified immunity defenses in court. Qualified immunity protects officials only when the law is not clearly established. But the Fourth Amendment is one of the most clearly established areas of law in American jurisprudence. Courts have consistently held that searches must be reasonable, and excessive intrusion or the deliberate disregard of known alternatives invalidates even otherwise lawful warrants. Political motivation is unconstitutional, and choosing escalation when cooperation exists is not a gray area. This means qualified immunity would not apply, exposing participants to profound personal financial liability, as is rightfully deserved. Beyond civil lawsuits, Federal officials who willfully violate constitutional rights can also face criminal charges under federal civil rights statutes if authority was knowingly abused, rights were intentionally disregarded, and if law enforcement was weaponized. Badges and titles offer no protection from the Constitution, which applies equally to everyone. This is not about one man or one mansion. It is about precedent. If the federal government can ignore the Fourth Amendment when it finds it convenient, or inconvenient for them to follow, then it can ignore it at any time, for anyone. The FBI's own documents demonstrate that cooperation was available, making the decision to escalate a deliberate choice. When raw power replaces constitutional restraint, accountability must be swift and severe. As James Madison, the father of our Constitution, warned us, the accumulation of all powers in the same hands may justly be pronounced the very definition of tyranny. We are at a critical juncture. The admission by federal agencies of constitutional violations, coupled with a lack of transparency until forced by Congress, demands immediate and unwavering scrutiny. We must hold those in positions of power accountable for their actions and ensure that the foundational rights enshrined in our Constitution are never sacrificed for political convenience or bureaucratic overreach. Constitutional protections are under constant pressure, and staying informed is essential. This is why vigilance is required. Accountability is not a choice. It is a legal necessity that must be relentlessly pursued.